Okay, I hope everyone can hear me. As I was saying, I'm usually found on the other side of these types of events as a member of the press. I'm here today to, take the podium and speak on behalf of this group because I believe that a lot of my colleagues in the press, unfortunately, have failed at some basic duties of the media when it comes to the issue of campus sexual assault. And those duties, of course, are to present the facts, to check the facts, to show a certain skepticism toward narratives that are being presented, and to present both sides of the issue fairly, or, sometimes more than both. There may well be more than two sides in any given issue. A lot of these flaws became evident recently, at the end of last year, in the sensational story at the University of Virginia, when Rolling Stone magazine published a now infamous piece by Sabrina Rubin Erdely, which a lot of people probably initially thought was going to be nominated for a Pulitzer. That's not quite how it turned out. And, Sabrina Erdely hasn't been heard from since. It was a story that really had all these ingredients of a kind of sensational, very emotional story. The innocent and sort of naive victim, a freshman student from a rural area, who gets to the university and is all excited about her social life, and then gets invited to a fraternity party and is subjected to an absolutely horrific rape. And I will admit that when I first read the story, my first reaction was, this is absolutely horrible. And my reaction, by the way, was, this is, one reason why these cases should be handled by real courts and, real police and prosecutors, not by these Star Chamber kangaroo courts on campus, because what was being described was very clearly a matter for the justice system, as opposed to these tribunals that can expel someone from college. These were, by the account of the magazine, this was a woman who was lured into a dark room and, violently grabbed and thrown down and, held down, punched in the face, and raped for several hours until she got out of there bleeding and bruised and just in a horrible condition. I mean, if that had actually been the case, these men would deserve to spend a very long time in jail and, to hopefully go somewhere where they would not be able to do this to anyone else. I will say that the second time that I read the story, I had certain alarm bells going off where there were certain details that were just really not adding up for me. One of which was that this woman said that she was thrown through a glass table. Basically, she was thrown down on top of a glass table, which shattered as she fell, and apparently she was raped for several hours on broken glass. And then supposedly she ran out of the building when she passed out, and then when she came to, nobody was there. And I thought, that really doesn't really add up, because if somebody was brutalized that badly, first of all, it's really doubtful that they would be able to even walk, let alone run. And secondly, they would need immediate medical attention. Then she has a story of how supposedly her friends, she called her friends in a panic. They picked her up outside. She told them what happened. And they were primarily concerned about how reporting this rape would affect their social life at the university. And again, I thought, that really doesn't add up. I mean, okay, maybe I could see if this was one of those kind of gray area he said, she said cases where, she had too much to drink and she wasn't quite sure what happened. Then I could sort of see a friend saying, well, do you really want to make trouble over this? But this was bizarre. And there were just, as I reread it, there were more and more details that were just really, really strange. I was thinking of writing something about this I was looking for leads to, talk to someone, and the thing that was interesting was everybody at the fraternity that this allegedly happened to was banned from speaking to the press. So there was really, I couldn't even start to look for ways to fact check this. And then what happened was that several days later, a blogger named Richard Bradley, who is also the editor of Worth magazine and former editor of George, now defunct magazine, published a blog post basically saying, there are a lot of things about the story that don't really seem to add up. Including the fact that, this woman's friends react in this really strange way, and she doesn't seem to be nearly as physically injured as she should be, given the details of what she's talking about. Then it was picked up by my colleague Robbie Suave at Reason Magazine, who was called an idiot for his labors by a blog called Jezebel. And initially the reaction to the questioning was just incredibly negative. And then it kind of started snowballing. The Washington Post began to investigate this, and, to make a long story short, the story completely fell apart. When people actually, one thing that came to light, by the way, was that it became obvious that the author of the story, Sabrina Erdely, had never made any effort to interview the men who had supposedly done this, even though it was pretty clear that the young woman, Jackie, knew the names of at least some of them. And that was something that was a red flag for a lot of people, because it is normal when you're writing about an alleged crime to give the side of the accused. The Washington Post tried to spoke to the young woman again, interviewed some of her roommates, interviewed people who had seen her around that time and didn't see any sign of injuries on her. Eventually tracked down the young people who picked her up that night, and apparently she did make a panic call, but at the time her story was very different. Her story was that she had been forced to perform oral sex on some fraternity guys. Then it turned out that the man who supposedly took her to that party didn't exist. It turned out that she had essentially made up this guy who was supposedly courting her, and ooh, my goodness, I'm running out of time here. So the story completely falls apart, and since I don't have a whole lot of time left, I'm going to say, this was very typical of how, oh my goodness. Yeah, this is my time clock. Yeah. Yeah, please do. Yeah. Right. I didn't realize that I was taking up so much time with the UVA story, but the upshot is, and I'm just going to try to wrap this up in a minute, a lot of stories, unfortunately, that have not been investigated as much as this one has, really have not been reported much better. If you look at, I did a story for the Daily Beast on the Brown University case involving a young man named Daniel Kopin. And the only reason I was able to do that, by the way, is that he was outed by the Brown Daily Herald against his will after he was suspended. Then when he was supposed to return to campus, the young woman who accused him, Lena Sklove, went public, and anyway, he was forced to drop out. But it turned out that there was just a host of details that did not add up. When I looked at the source materials, it turned out that there were witnesses who saw the two of them immediately after the alleged rape, and it was pretty clear that, the woman was not acting like someone who had just been raped. She did not ask for help. She didn't seem traumatized. It is very standard for the media in these cases not to get the side of the accused and to go with the account of the accuser. And the reasons, I'm going to go into that in Q&A, and for hopefully some of the other people are going to go into them. There's a reluctance, obviously, to question somebody who says that a terrible thing happened to them, and I think that's understandable. But I think there is also a certain ideology that is involved, which is this, what I would call pseudo-feminist notion, because it's really kind of a new pedestal for women, that you don't question the word of someone who says she was a victim of sexual assault. And that is something that I think the media really have to start looking at, and they really have to start approaching these things differently. And, I'll just leave it there, and hopefully we'll have more time in the Q&A.
Good morning. My name is John Bansaff. I'm a professor of public interest law, George Washington University right here in Washington, D.C., Disneyland on the Potomac. And I'm perhaps best known for my anti-smoking activities, getting anti-smoking messages on radio and television, and banning cigarette commercials and banning smoking in all the public places, both here and now abroad. But I'm basically an equal opportunity litigator. I go after everyone. And among the other things is that I have brought about 100 legal proceedings successfully challenging sex discrimination against women. I was the one, believe it or not, who got the first women admitted to the Cosmos Club and the Metropolitan Clubs here in Washington, D.C., previously all male bastions. I got the first woman ever admitted to a state military academy. And for my troubles, I've been called a radical feminist, not just once, but in 2 different newspapers. I'm not sure that fits, but that's what I've been called. But in any case, I guess nobody can really call me anti-woman or a male rightist or an arch-liberal or, arch-conservative or libertarian. But like my 32 colleagues, law professors up at Harvard and 16 law professors up at U of Penn, and that includes a large number of women, including some who identify themselves as feminists, I'm very concerned that students who are accused of date rape and other sexual assaults on campus are being illegally denied their rights as established and protected by the U.S. Constitution, primarily due process. Fortunately, there appears to be a rather simple solution, which also happens to be my motto: sue the bastards. And that's what I'm going to be talking about. More specifically, if a state school, and it has to be a state school, refuses to provide the fundamental constitutional protections established under our U.S. Constitution and primarily under the Due Process Clause, and that includes, at a minimum, the right to an impartial hearing at which the student is permitted to know the evidence against him and to cross-examine his accuser and other relevant witnesses, and possibly even to have an attorney. Not only the colleges, but the presidents, the deans, the faculty, and other flunkies who participate in it can be sued individually, not just for damages, but also for attorney's fees. And that's what I'm going to be focusing on. I've only got 8 minutes, so I'm focusing solely on, or largely on, cross-examination, but there are many other aspects to it. Why does this occur? Well, first, it is absolutely positively clear, nobody denies it, that state schools must provide due process in student disciplinary hearings leading to expulsion. There's no question about that. However, as administrative lawyers across the country, including me, constantly remind our students, yes, due process applies, but what does that mean? Specifically, what process, what procedural protections are due in any given situation, because it varies with the situation. Now, fortunately, the U.S. Supreme Court has given us a formula for determining this, and it stood the test of time for over 40 years. So what we have to do is look at each possible procedural protection: an impartial decision maker, notice of the charge, right to examine, right to cross-examine, etc. We look at each one individually, and we ask this question: if somebody is going to be faced with the loss of a serious privilege, that could be a job, that could be a loss of benefits, or it could be being thrown out of school with the stigma that attaches to that, then the entity must adopt any procedure likely to help prevent a false loss of that benefit, provided it is not too expensive or otherwise too burdensome. It is a balancing process. So, for example, in a case where a person faced a loss of welfare benefits based upon testimony from neighbors, which might be biased and might be inaccurate. Supreme Court said they have a right under the due process to cross-examine that neighbor. On the other hand, years later, somebody faced with the loss of disability benefits might think it's the same, but it's not. The same Supreme Court said due process applied, but it did not require cross-examination. Why? Because when you talk about disability, the awards are usually based upon doctors' written reports. It's rather unlikely that these reports are going to be inaccurate or the doctors are lying. Therefore, you don't get to cross-examine. Now, what do we do in a case of college date rape? Well, usually, of course, there are no eyewitnesses who can say, well, this is what I saw. What we usually have is a he said X, she said Y. Their credibility is directly on the line. That is really the only issue, usually, did she or did she not consent? So it seems to me that under those circumstances, cross-examination is absolutely essential. Indeed, my former colleague, most quoted Wigmore, very frequently quoted in many law opinions, said, beyond any doubt, cross-examination is the greatest legal engine ever invented for the discovery of truth. And obviously it is most vital in those situations where there is no other evidence, where it is he said, she said, and so on. So I think in these cases, very clearly, there ought to be a right. Indeed, the cases suggest it, and I've attached a few to my remarks, that there must be cross-examination. There may also be a need for a lawyer, not only to prevent, in the case where the person might be prosecuted, self-incrimination, but also because an 18-year-old faced with his future on the line is probably not a very skilled cross-examiner to help bring out the truth. Now, the important thing about this is that it cannot be changed. The Department of Education cannot change it. Universities cannot change it. Congress cannot change it. These are fundamental due process rights written into the Constitution, and I don't care what DOE or Congress or the individual universities say. So what I'm planning to do is to work with others to put college presidents and other administrators on notice. They must begin and insist upon providing due process protections in these kind of situations, or they will be sued. If you think these are just empty threats, a number of years ago I threatened to sue just one guy at my university, the risk manager. They didn't believe I would do it, so I sent them a copy of the complaint, and the next day they banned smoking across the campus. Working on the inside of academe, I know that people are scared witless of lawsuits. And it's not just the college again. Under 42 U.S.C. 1983, you can sue the president, you can sue the faculty. In one case, you can sue the coach, and they will be individually named. That will go on their credit reports. They may have to go through pretrial discovery. Very unpleasant if you haven't gone through it. Old gypsy curse. May you be sued, it be in the right. Not a good thing to do. And even if the university says, oh, don't worry, Professor or President, we'll reimburse all of your expenses. Yeah, you going to trust the university's attorney to represent your interests as strongly as those of the college or university? I sure as hell would not. They're likely to throw you under a bus, so anybody sued may have to go out and get their own attorney. So once they are put on notice, legal notice, they can be sued, and if they refuse to provide the protections guaranteed to these students by the United States Constitution, immutable, then my motto and my answer is sue the bastards. And that includes not just the colleges, but the administrators. Well, that probably exhausts about my 8 minutes, so I could get into a lot of others very quickly. But without further ado, I'll mention I do have a handout with a lot of the information, but on to our next speaker.
Good morning, and thank you all for coming. I'm Susan Kaplan, and I'm speaking, my title of my speech is The Infallible Victim and Unimpeachable Trauma, Fallacies and Bias in Title IX Tribunals. I am purposely creating some hyperbolic language because there is already so much hyperbole entrenched in this issue. We have accusers who enter into the tribunal with the mantle of victim, not even alleged victim, sometimes even survivor. There's a presumption that this survivor is suffering from trauma, not even garden variety emotional distress, which is a far more deflated term. I come to this, and I come to you from the trenches, so to speak, actually advising. I'm an attorney, but I can only rise to the role of advisor on campus for students who are accused. And as we just heard, I am the coach in the background for an 18-year-old, a 19-year-old to kind of manage this heavy burden. And, you know, no pun intended, but he's the accused. The burden actually should be on the accuser side, the burden of proof. But in fact, because of this infallibility that even Kathy spoke of, where there is no skepticism when it comes to the accuser, the burden automatically shifts to the accused, it seems. I come to this with some academic and feminist cred as well. Before I was an attorney, I was an English professor at VMI. I was female number 4 on the faculty back in the day when it was an all-male corps. I was one of the first, I headed a department, the honor college, as a woman there. And I was probably one of the first faculty members, probably the first woman to visit a student in prison who had been arrested for date rape. We're talking about the late 80s, early 90s. That was the world we were in then. Date rape, if you recall, that has kind of gone out the window and has been replaced by various waves of feminist campaigns where date rape kind of turned into rape is rape, which in and of itself was troublesome, kind of assuming, again, another kind of infallibility. Couple rape is rape with trust. If a woman says she was raped, we don't even need a tribunal. We don't need any adjudication. We just simply have a show trial, if even that. But that was seemingly the rhetorical ideal that followed the failures of date rape. By the way, the student at VMI, because of the honor program at VMI, just being accused of a felony, he was a goner. There was nothing back then. I remember going to visit him in the county jail with his homework, and then before it was due, he was gone. He was out of state, and that was that. So that stayed with me. It stayed with me all the way up till the point after becoming a lawyer and not even involved in these issues. A former colleague called me just recently, post 2011, the key year in all this, and said, Susan, please, I know you're a lawyer now, but I have a female student, and she was raped, and she needs your help. I said, well, I'm not a criminal attorney. I mean, what does she want my help for? You know, we have a criminal justice system, go to the police. No, you don't understand. She got raped by a professor, and VMI is doing nothing about it. I said, well, why should VMI be doing anything about this? I mean, this is how, I mean, my knee-jerk lawyer chops wasn't even being triggered by this. I said, well, why doesn't she just go to the police? Why are you coming to me? He talked me into talking to her. I heard the story. It honestly sounded like something rising to familiar criminal territory, not this inflated criminalization that we're dealing with here, but it might have occurred to her. And I said to her, why don't you go to the police? It was as if I was speaking gibberish. I mean, it was just like, no, the issue is VMI. And I said, well, I don't know what I can do for you, really. And I started investigating this, and now I find myself actually representing students accused. So we come into this situation with these presumptions, which is very counter to what you would find in the civil arena of the courtroom, where even, as I already mentioned, garden variety emotional distress. That is emotional distress that isn't verifiable medically. It's just sort of the plaintiff, and the plaintiff still has the burden of proof. The plaintiff is in the same role as the accused, or we can make that parallel comparison, is saying, yeah, I didn't go to a psychiatrist. I'm sorry, I can't afford a psychiatrist, perhaps, but which is usually the case. But believe me, when I lost my job, when my neighbor killed my dog, when whatever, all kinds of problems that arise, I couldn't sleep. I felt so hopeless. My hair started falling out. I've had cramps nonstop for the past 6 to 8 months. People recognize that as within the realm of possibility for emotive responses to stress. But here's the rub. Who knows who you are? Who knows what other stress factors in your life? You still have to verify. You have to be able to go under cross-examination that has already been recommended by the preceding speaker and say, well, no, I've never had cramps before. My hair has always been full and lustrous until this happened. I've been the model of health. Or yes, of course, I've had stress up and down, but it's been 2 years since I ever had to take a sleeping pill or whatever. You try to, even without medical verification, establish where you are emotionally. In the Title IX tribunal, if she's crying, she's not lying. And, it is so easy to come in and say, oh, let me also clarify. I think a lot of us here are familiar with the context of complaints that are being asserted here. There is sort of a continuum. I'm dealing with the kind of complaints that Janet Haley, in her Harvard Review article in February of 2015, Trading the Megaphone for the Gavel in Title IX, identifies as the hard cases. They're the hard cases, but they're the ones that are most familiar to us. They're the most pedestrian. These are the interpersonal cases where there might be an ongoing relationship between the parties, or even if it's informal and casual, there is a pattern of consent leading into the encounter. There might even be post-relationship, post-event relationship issues going on. There's usually alcohol involved, and there's a lot of ambiguity about what happened. There's a lot of gray area working on the continuum of seduction to force, if you will. These are the hard cases, as Ms. Haley talks about them. The easy cases are the ones where the Mickey is put in the drink and the victim is knocked out and raped and all that. That's easy in terms of we know what to do with that. We have a mechanism. It's these gray area cases that are hard. In these gray area cases that are hard, there is a, boy, I'm towards the end too, without hardly saying anything I want to say. There is the victim comes in and declares what is called trauma, her survivorship, but keep in mind what the context was. A mostly consensual situation fueled by alcohol. She has a choppy notion of what kind of happened, but it didn't. For various reasons, it's hard to put a finger on. And she's claiming trauma. The trauma carries into the first thing it does is it is a punitive response without any pre-hearing. Usually, the student, the accused, winds up with some kind of, quote, interim measure, which can be anything from a no-contact order to absolute probation and removed from school, removed from his dorm, with no challenge to whether anything happened at all. To sum up, I just want to carry this through. I had a student who was just found not responsible for the claims against him in a tribunal. However, part of the claims against him was stalking. However, in the final report, the panel, in their finding of fact that there was no stalking, nevertheless tips its hat to the accused and kind of apologizes. And they say, though the panel is sympathetic to the accuser's experience and appreciate her distress, we find that the student didn't stalk. Well, then where's the distress coming from? To sum it up, even though he was found not responsible for anything, and it was also sexual assault, there was a whole panoply of things, he's still under a no-contact order so long as he remains on campus with respect to the accused. He still has stink on him. There is no innocence here. So if you come in with a presumption, you wind up with a presumption of victimhood. What you wind up with, what you're really dealing with, is a presumption of guilt. He never can achieve innocence under the system. Even if he's found not responsible, they can't find a single fact against him. We say, well, listen, even under preponderance of evidence, we couldn't find you faulty of anything, no contact order. Okay, so that's what we're dealing with. Thank you. My next speaker.
In the attached handouts, I've explained how the Office for Civil Rights, where I used to work, has made punishment of innocent students more likely and in some cases inevitable through its rules on how colleges must handle sexual harassment allegations, which cover both verbal harassment and sexual assault. For example, in recent investigations, OCR has required colleges to impose interim measures against accused students before they ever receive a hearing on the charge against them, measures that can include expulsion from a dorm and classes shared with the accuser. In its April 2011 Dear Colleague letter, OCR instructed colleges to restrict cross-examination, even though the Supreme Court has declared that cross-examination is the greatest legal engine ever invented for the discovery of truth. It also ordered colleges to abolish the clear and convincing evidence standard that once was the norm in college discipline. OCR also has recently required some investigated colleges to conduct individual complaint reviews for all allegations in past academic years to see if the college took steps against harassment in each case. That creates the risk of students being investigated all over again for an offense the college previously found them not guilty of, much like double jeopardy. But a bigger threat to innocent students is the massive financial risk colleges face if they do not swiftly expel accused students. Thanks partly to OCR stacking the deck, it can be much cheaper for a college to expel a possibly innocent student than to find him not guilty. Even before OCR's recent rules changes, colleges had massive incentives to suspend or expel students who might be guilty of sexual assault or harassment. For example, last year, the University of Connecticut settled a Title IX lawsuit by paying $900,000 to a student who alleged sexual assault. In 2009, the University of Arizona paid $850,000. In 2007, the University of Colorado paid $2.5 million. A jury awarded $1 million against the Pine Plains School District to a racial harassment plaintiff. And if students win their Title IX lawsuit, the school also has to pay their attorney's fees under a pro-plaintiff rule known as the Christiansburg Garment Rule. Colleges' financial risks are multiplied by the fact that in addition to being sued by students, OCR can cut off all their federal funds and student financial aid. OCR doesn't view itself as being bound by a court's earlier ruling rejecting a student's harassment lawsuit, and it argues that the standard of culpability is less in an administrative investigation. Moreover, although OCR is not likely to cut off a typical college's federal funds, since a college will do whatever it takes to appease OCR and prevent that from happening, that doesn't mean a college will not experience massive costs. When OCR investigates a college, the college has to devote a small army of employees to cooperate with its investigation. Moreover, even when no court would award damages to the complainant, OCR will. It has recently given itself the power to award monetary damages against colleges, even in situations where the Supreme Court's Davis decision says damages would be inappropriate under the Constitution's spending clause. To resolve a recent OCR investigation, Tufts had to pay a complainant monetary compensation, even though OCR never specifically found that she was sexually assaulted, because OCR ruled that Tufts had wrongly allowed the accused to submit the complainant's private medical records to show that the complainant had lied and that he was thus innocent. In its 2014 harassment guidance, OCR generally imposes liability on institutions even if they do discipline those who've engaged in sexual harassment, if they do not also remedy its effects. Even punishing the harasser likely will not be sufficient, OCR said. What does OCR mean by remedy? In its 2013 retaliation guidance, it suggests money, saying OCR will determine which remedies, including monetary relief, are appropriate based on the facts presented in each specific case. So in addition to being sued by complainants, colleges may also be forced to pay money by OCR. And that's just the beginning. In addition to suing the university itself under Title IX, the accuser can sometimes also sue individual state college officials under Section 1983, or individual officials even at private colleges under state sexual harassment laws that reach further than Title IX, like in New Jersey or Massachusetts. By contrast, a state college that expels an innocent accused usually can't be sued, even if he is probably innocent, since the accused only has a right to procedural due process, not any substantive finding of guilt or innocence. So as long as the school goes through the motions of giving him a fair hearing, it can usually kick him out even if he's not guilty. Even if a student does successfully sue over a due process violation, it's usually the individual school officials who can be sued, not the university. Private colleges are not even bound by constitutional due process guarantees, although they can sometimes be sued for breach of contract or consumer fraud. Lawsuits by railroaded male students typically don't generate a damage award big enough to pay a lawyer's bill, making it hard for them to obtain a lawyer unless they have a wealthy family. Courts only order a college to pay a student's attorney's fees if the student is a discrimination or harassment plaintiff, not a breach of contract plaintiff. When a male student successfully sued the University of the South, he got only $26,000 in compensation, which was less than he was billed by his lawyer. The net result of these financial incentives and OCR's policies is to stack the deck against the accused in campus disciplinary proceedings over sexual harassment or assault. And yet, at the same time, OCR has failed to encourage rape victims to report crimes to prosecutors who can put rapists in jail where they belong and thus protect public safety. Federal education officials who enforce Title IX have said it does not require schools to report alleged sexual violence to police, noted the Washington Post on January 26. And indeed, when Virginia state senators sought to mandate reporting of all rapes to the police, OCR's interpretation of Title IX apparently proved an obstacle. The chairman of the House Courts of Justice Committee said the Senate bill may violate Title IX confidentiality requirements mandated by OCR.
Hi, my name is Cindy Garrett. I'm on the board of directors for Families Advocating for Campus Equality. I became involved in this issue when I, as an attorney, realized that this was happening, and I kept saying, but this is America, you can't do that. And the more I read, the more I said, but this is America, and so I decided I needed to do something to help the kids, especially the ones that can't afford lawyers. The problem is that the colleges, somebody said earlier, they're between a rock and a hard place. I mean, they either choose to comply with what they've been told, or they lose their funding. I mean, it's compliance or cash, and it's a really tough position for them to be in. I think the biggest problem is, as Susan so articulately explained, the concept that the victim is telling the truth. Believe the victim. It's a presumption that victims don't lie, and literally the colleges have been told to believe the victims. This causes a burden to shift to an accused, effectively, to prove that he had consent or he had a reasonable belief that he did have consent. But his intent, his actual intent, unlike a crime, is completely irrelevant. It seems that, he doesn't need to have any intent to harm. He doesn't need to have any intent to obtain sexual gratification. He has only need to have a reasonable belief that she consented or somehow prove that she did consent. The difference, though, between the criminal process and the campus process is that in the criminal process, he's presumed innocent, whereas in the campus process, she's presumed to tell the truth. In the criminal process, the burden is on the accuser to prove his responsibility beyond a reasonable doubt. However, in the campus process, by lowering the burden of proof to preponderance, this now requires the accused to have a higher burden than just raising reasonable doubt. He has to show by the same preponderance that she's either lying or that he did have consent or reasonable belief to show that she had consent. Also, it seems from the cases, the people that have contacted FACE, we've had about 100 since we went online in July, I think. You can tell that the colleges are really taking this to heart. I mean, I have one client, I say client, he's a father that I talk to every week or so, you know, who's obviously terrified his son is going to be expelled and, you know, never be able to complete the education that they've been planning for his entire lifetime. And he actually took a tape recorder into a college administrator to talk, secretly tape recorded, which I guess in this state it isn't always illegal, the state he was in. And I have heard the recording, and the administrator basically said to him, "Tell your son to give up. We find him all guilty. That's just the way it is nowadays." Of course, when he provided that evidence, that recording to the school, they said, well, he doesn't speak for us. So, you know, it really didn't get him anywhere, but it was very frustrating. To exacerbate the problems, we have this affirmative consent, not this craziness that's, you know, I'm a California attorney. I started lobbying against the California consent bill, and now it's spreading like wildfire because, of course, whatever California does, everybody has to follow. At least from my perspective. So now, another presumption that's coming up through the affirmative consent policy is that he is the initiator. It is always the man that is presumed to be the initiator. And what falls from being the initiator is then he's responsible to obtain her consent. He's responsible to ensure she's not intoxicated or incapacitated, He's responsible for his own intoxication as well, and he's not allowed to use his own intoxication for his excuse, as an excuse for him misreading her consent. So here we have the man presumed to be the initiator, while the woman is presumed to be the recipient, and she's excused from anything. She's not responsible for any alcohol code violations. She doesn't have to judge his consent. She doesn't have to judge her own consent. And worst of all, her intoxicated or impaired judgment is relied upon to find him guilty. I mean, it's crazy. We have a case, I had a case, an attorney that I talked to has a case in Maryland where it wasn't even sex. I mean, it was kissing, but besides that, they were both at a party, and every single witness said she went after him. Every single witness. And yet, the school found them guilty because he was a man. So I think it's pretty apparent that this is a gender discrimination issue. It's always the man. Why is it always the man? I mean, it may be a statistical likelihood that men initiate sex more often than women, but that doesn't mean that you can blame one individual just because it's statistically likely. A lot of the cases that we see involve ongoing relationships, girlfriends, ex-girlfriends. I can't tell you how often that happens, where they're in the midst of a dating relationship, and all of a sudden one night she decides, that maybe she didn't feel comfortable with how he approached her sexually. Or maybe a year later, after they break up, she decides this. I mean, this is very, very common. And the problem that I have with that is, I think back to college, and when we started college and we were all learning. I mean, it's not just learning about your career, It's learning about how to negotiate relationships. I mean, that's what college is for. You're there to kind of, trial and error. You reach out and maybe you realize it wasn't the right way.
My name is Joshua Strange, and I want to start with, it's going to be kind of a running mental image for everyone. I remember the day where I first got accused of sexual assault at Auburn. It was my ex-girlfriend who was accusing me, and I had no idea what to do. And I always tell people that when the accusation came across to me and they told me about it, it was as if I had somehow wound up at the bottom of this pit, and all around you is just darkness. It's just completely black, except for the light of one match that's in your hand, and that match is burning. And that's all you can see. And it's just you by yourself, cold, dark, and alone. And you're trying to figure out where to go next. You're trying to put one foot in front of the other, just trying to go day to day and make it through and just somehow find the light at the end of the tunnel. And that's how it went. That was the world that I lived in. When I was at Auburn, and even before Auburn, I was always the guy who just had a very large group of friends. I loved hanging out with people. I wasn't really a dater. That just wasn't my prerogative, I guess. I just wanted to have a large group of friends and just hang out with pretty much everybody. And that's what I did until this accusation came across. I used to walk across Auburn, and just going from one building to the next, I'd run into 20 or 30 people that I knew. I was in a fraternity. I was having the time of my life, literally. And then I got accused, and I watched all of that disappear. It was as if I turned into a leper. People didn't want to have anything to do with me. My fraternity removed me from my position. I was the chaplain of my fraternity, and here I am accused of rape. They removed me from my office. They put me on inactive status. My friends who weren't all that close to me abandoned me. I found myself, kind of sitting in my apartment by myself most nights, just trying to figure out what to do next. But I did retain a core group of friends, which is what really got me through. But I didn't really want to go anywhere. It was really hard for me to go to campus because just walking across campus, people would start to stare at you. They'd point at you. You'd see them whisper something to their friends. I remember there was a Chick-fil-A on campus in the student center, and I went there. I had about an hour between two of my classes, and I figured, well, I'll get some lunch so I'm not hungry in my next class. And I was standing in line, and there were these two sorority girls standing in front of me. And one of them turns to the other one and says, "Oh, did you hear about that Josh Strange guy?" And I'm standing right behind him, and the other one says, "No, what happened?" And she said, "He raped some girl in Sigma Kappa sorority a couple of months ago." And oh, I had no idea about that. Oh man, what a freak, what an ass. And I'm standing right behind him, and I went home. I jumped out of line. I went home and just sat in my room and didn't know what to do. And that was a day-to-day thing for me. And then it came down to the hearing. Walking into that room on that morning and seeing they had hung a black sheet between my accuser and myself in the middle of the room, so I couldn't see her, so I couldn't, quote, cause her any more distress. And seeing the panel of 5 people up in front of me, which was a fisheries professor, a professor of liberal arts, a male student, a female student, and then the chairman of my panel, which was a librarian from the Auburn Library. Those were the 5 people who were getting ready to determine my educational and even career future. My entire life boiled down to a 4.5-hour hearing, and that was it. And I remember walking into the room and just this black cloud, as if it couldn't get any darker than it already was. It got a lot darker, really, really quick walking into that room. And I just remember thinking, this is not going to end well. This is not going to be good. This is going to hurt. And we sat in there for 4 hours, 4.5 hours, however long it was. Trust me, I had no concept of time at that point. I just wanted it to be over. And I was so nervous, I couldn't even tell you my own name when I first walked in there. And yet here I am expected to defend myself. It was basically next to impossible. At the conclusion of the hearing, when we were getting ready to hear the panel's findings, so to speak, just this sick feeling was just constantly there with me, and I was sitting there listening, and I heard the words, "We find you in violation of the Auburn Student Code of Conduct, and we recommend that you be expelled." And that's what I heard. And I said, okay. And I stood up with my attorney, and we exited the room, and I kind of went black for a minute. I think I might have blacked out for about a minute or two. And we walked over to my family, and I looked at them, and here's the university that I had always wanted to go to since I was 6 years old. No rhyme or reason to it, just wanted to go to Auburn, wanted to be a Tiger. And I looked at my parents and my friends who were there and said, they don't want me here. I'm gone. That's it. And they started talking amongst themselves, and I just I think somebody asked me a question, and I just kind of looked at them and shook my head and turned around and walked out, and just walked out the door. And went and sat on a bench and tried to figure out what to do next. And I want to take you back to that well that you're in, or that dark place that you're in with the match. When that expulsion was mentioned, it was as if something ran up and blew that match out. And now it's just you in the dark by yourself, not knowing which way's up, down, left, right, where the door is, where the exit is, where the light is. That light didn't exist anymore. And that's the world that I lived in for years. This all happened back in 2011, 2012, and here it is, 2015, and I'm still trying to get over it. It's never going to go away, and it's always going to be a cross that I'm going to have to bear. It's extremely painful, and knowing that all of my friends that I retained from Auburn, they're going to get to go back and go to alumni tailgates and alumni events and football games, and here I am, odd man out. My best friends in the world, I can't go tailgate with them. I can't set foot on campus. I can't go back to my fraternity house. I can't go see any of my friends because they don't want to have anything to do with me anymore, most of them. And I've had to somehow figure out how to deal with that. And it's just this sickening feeling, trying to just move on and go day to day. And I've heard my thoughts echoed in everyone that I've spoken with. I speak with young men who are going through this almost on a weekly basis, and those are just the ones that are reaching out to me to speak. And it's a constant feeling that we all share, and we don't know what to do. Thankfully, I can give them a little bit of advice and try to prepare them for it so that it doesn't hit them quite as hard as it hit me. It kind of softens the blow a little bit when you can tell them. But at the same time, the hardest part of what I'm doing right now is having to say over the phone to someone, your life is getting ready to get this much harder, or it's getting ready to, your collegiate life is getting ready to end. And that's one of the hardest things that you ever have to do, because some of these guys, that's the only school they wanted to go to, just like me with Auburn. That's all I wanted to do. And I have to tell them that your school is getting ready to reject you, and you're going to have to find a way to be okay with that, because there's not that much that you can do to stop it. And it's a constant battle. It's getting a lot better nowadays, thankfully. I can kind of stand up here and be able to do this kind of thing now, and it's helps me in a way, but it's also really hard because you immediately go right back to that place, and you start thinking about it again, and you start remembering all the feelings and all the emotions and just the despair. But it does start to get a little better, but it will never be okay for the rest of my life. And like I said, it's a cross I'm going to have to bear forever. And it's not one that I would wish on anyone. It sucks pretty bad, but it helps knowing that I'm not the only one going through it, but at the same time, I don't want them to. And so that's why I'm here. And thank you very much.
Hello, Blake Neff, Daily Caller News Foundation. I thought I would ask Kathy Young, because she unfortunately ran out of time. What are some other examples that you think stand out besides the UVA case of the media misreporting sexual assault cases due to bias or misunderstandings or whatever?
Right. Thanks very much for the chance to elaborate on this a little. I think it's the peril of going first. You know, I didn't really quite calibrate my timing well. Anyway, yeah, I mentioned the case at Brown University of Daniel Kopin and Linus Clove, which I wrote about for the Daily Beast. There were just a lot of details in that case that got completely misreported. The other case that I also covered for the Daily Beast was the Emma Sulkowicz case at Columbia University, the infamous mattress girl. That was kind of a fascinating case because when I first read the account of that in the New York Times, I thought, you know, yeah, that sounds like a real injustice has been done, because here is supposedly a man who is being accused of by 3 different women of sexual assault, and somehow, you know, he beats the rap on all these charges, and, you know, what are the odds that 3 women are going to falsely accuse the same man of rape? Until I looked into the details, and it turned out, among other things, that all of these 3 charges were connected to each other. There was a very good possibility that these were 3 women who were kind of goading each other to reinterpret their relationships with this guy kind of retroactively as being abusive. And, you know, there are a lot of other details in that case that turned out to be much, much more complicated and nuanced than, you know, was reported in the New York Times, among other things. So these are just 2 cases that come to mind. There's another, the Jameis Winston case, which Stuart Taylor has written about on Real Clear Politics, and more recently at National Review, where, you know, he lays out a really good case that the New York Times, in its coverage of that story, has just been very one-sided and has repeatedly ignored, you know, evidence pointing to the fact that the accuser was not being truthful. And this is kind of interesting, too, because, you know, this is a case that taps into such a paradigm of you know, historical American injustice. This is a young black male being accused of rape by a white female. I mean, this is like, you know, To Kill a Mockingbird, really. This is kind of the classic story that we should all be familiar with, and that should kind of tap into this pattern. And, you know, among progressives, you know, first and foremost. And yet, you know, here we have the media kind of embracing this narrative, which, as it turns out, is very factually shaky. So this is another case. Some of the cases, and I don't want to really talk about that too much because I'm planning to write about this, but one of the cases, and I'm being deliberately kind of evasive about the specific name, but one of the cases profiled in The Hunting Ground, besides the Jameis Winston, you know, this is the movie that's being released now. The Jameis Winston case is part of that, and they, you know, they're interviewing the accuser and, you know, totally taking her word as fact. But there's another case, another story in that movie, which I'm currently looking into, which I think is going to turn out to be another Jackie from UVA, which is this is a case where there's no specific man who's being accused. But this is, I think, someone who's accusing the university of being insensitive to her. And, you know, I just have a very strong sense that this is a completely kind of confabulated story. So, and again, it doesn't, if you read the details of what this young woman is claiming, there are a lot of things in there that really just do not add up. And, you know, the fact that this is being reported as fact, that this is not even being questioned, is kind of shocking to me. Can I just make one more quick remark? It's kind of ironic that the other story that the other kind of area that I'm working on these days is Russia. And I'm looking at the Russian media and the way that they report this complete kind of alternate reality, where the propaganda reality, where, you know, Ukraine is engaging in genocide against ethnic Russians, etc. And and then I'm thinking, the way that our media are reporting sexual violence on campus is really, unfortunately, not much better. It's the same kind of, this hyper-emotional approach to this, these claims that are being taken completely at face value, this refusal to question the official version, this kind of tendency to label anyone who questions the official version as a bad person, as well unpatriotic in the case of Russia, or a rape apologist in the case of questioning the kind of dogma about sexual assault on campus. So I think this is a case where I think the American media really, really need to take a good look in the mirror, because they have been acting really more, for the most part, as vehicles for propaganda than as the media in a free society doing what they should be doing, which is looking at the facts and reporting both sides. Thank you.
Thank you, Kathy. Okay, yes, I think you were next in the back.
Hi, I'm Tierney Sneed. I'm from U.S. News, and I actually have 2 questions, if that's okay.
Certainly.
My first question is, we've heard some anecdotes about, these disciplinary systems being stacked against the accused. Is there any data? I don't know how hard it is to collect data since it's, internally within schools, about, how many cases go the way of the accused versus the accuser. If anyone's looking kind of like a broader look at the statistics behind, whether we are seeing a kind of a systemic bias against the accused. So my first question, if any of you have looked into that.
There's insurance data apparently on colleges, and apparently they find that, of course, I think the data set to some extent goes back before recent education department rules, which I've said stack the deck against the accused, so they may not be very probative of how they're doing it right this year. Because in 2011 and again in 2014, the Office for Civil Rights ratcheted up the liability for colleges and essentially pushed down the rights of the accused. But I think they found something like 45% they expel or suspend, and then like a smaller percentage they find them not guilty, and there's some other percentage, and I've forgotten what category it falls into. And again, these are not just rapes. I would imagine that the percentage of people who are expelled for rape is higher, because if you're found guilty of rape, logically forcible rape, you should be expelled. I think these are a broader category of sexual misconduct cases that were covered by the insurance data. And of course, some of the Justice Department definitions of sexual assault now, most of the conduct that falls within them is not forcible rape. It's basically offensive sexual touching, which could be somebody, maybe even somebody kissing somebody without their consent. So the data set covers more than just rape, and I think it does break down the percentages. And again, I think it runs back a number of years, and I don't know if there's a trend line, rising percentages expelled over since 2011 or since 2014, when the incentives for colleges to expel people rose. And again, these are not all forcible rapes, so for some offenses you wouldn't expect an expulsion as a matter of justice. Although you would, for a rape, forcible rape, you would obviously expect as a matter of justice they should be expelled and also be incarcerated. But I think if you Google it, you can find some data, I think, from the insurance, some insurance study, sponsored study that covers that.
So for those of you on the panel who say that colleges should stay out of this, should be left to the criminal justice system to prosecute these claims. Kind of the counter that I hear a lot to that sort of line is that the criminal justice system takes a long time. You see that it's really hard because of the nature of this he said she said nature of the crime, that the proportion of felony rape convictions is really low. And there's this interim period where the accused and the accuser are living in the same dorm, they're taking the same classes, she might not be able to pursue her education because she doesn't want to see him every day, or he in the cases of male accusers. Do you see a middle ground for colleges that maybe instead of necessarily expelling someone or permanently expelling, permanently punishing someone, but can kind of have a system to do some of these sort of middle ground measures?
I may be one of the few people on this panel or in the quote movement who agree that there should be something beyond the criminal justice system with regard to the typical date rape. And the reason is, in a typical date rape, you only have he said, she said. You rarely have any independent evidence. And if you apply the criminal justice standard of beyond a reasonable doubt, it is incredibly difficult, even if the prosecutor is motivated, even if the police department is motivated to get a conviction. So I've advocated, excuse me, a third ground, it's in the New York Times and elsewhere, which says also colleges themselves are not equipped to deal with these. And as somebody who's at a college, I can tell you firsthand. Our police, most campus police, are poorly trained and poorly paid. The idea that every college, not just mine, which is a big one, but all these small ones, should be able to have on staff people who've been trained and have the expertise to investigate sexual assaults and rapes, it just isn't going to work. You can't do it. And then our typical panels of the librarian and the professor of geology and so on, we can't handle water balloon incidents very well. We certainly can't handle date rape. A very simple, to me, answer occurs. In the Washington, D.C. area, we have some 30 different colleges. We have consortiums. We lend each other books. We swap professors. We do all kinds of things. Let there be a consortium for the Washington, D.C. area, funded in some equitable way by all of the colleges on some kind of fair, proportional basis. They would be able to handle all of the sexual allegations made. They could afford to have and keep on staff 2 or 3 or 4 people because they're covering 30 or 40 colleges. They would have the training. They would have the expertise to interview the victims fairly and properly, to get and preserve, in a legal sense, the evidence which is appropriate, and they would do so in a completely impartial way. Colleges, on the one hand, are pushed not to find rape. It can hurt their reputation. Who wants to be known as Rape U? They can lose the championship because the accused is the quarterback or on the basketball team. You can tick off a large donor. So they're pushed in that direction. Then the colleges are also pushed in the other direction by DOE and many of the activist organizations. But a consortium wouldn't be pushed anyway at all. They don't have donors. They don't have basketball teams. They're completely, totally impartial. They would build up over time a detailed protocol for handling these situations in a completely fair, impartial manner. How do we adjudicate them? Do we turn them over to, I think you said, the librarian and the professor of Slavic languages? No. Right here in Washington, every day, every week, we have arbitrations. Retired judges, retired law professors like me, I guess I'd be looking for a new job. They sit on arbitrations. They make $1 million, $100 million fair decisions because they're trained to do so. So instead of turning it over to the professor of Slavic languages and the dean in charge of parking and toilets, we could turn it over to a body of totally impartial arbitrators, and they would make the determination. That's one way of dealing with it. Somebody else mentioned this problem of, I got to go to the class with this guy, I got to see him in the library. I was amazed when I read the testimony at some of these hearings. Something like 40% of the women do not want to report, not because they're embarrassed, not because they're embarrassed. In many cases, they don't feel they want to expel the guy. Yeah, what he did was wrong, he should be punished, but expulsion, that's too much. Others say, well, maybe it'll be nice to expel him, but if I do that, all my girlfriends are going to come after me and all my guy friends are going to come after me, and I don't want to do that. And so they don't report. The reason is today most colleges don't have an intermediate position. I would like to see many colleges have an intermediate position, something like the restraining and protective orders we have in civil society. You don't require proof beyond a reasonable doubt. In many cases, not even proof beyond a preponderance. If somebody comes in and makes a credible allegation, okay, let's separate it. Maybe we move her out of her dorm, or I'm the guy, I move out of my dorm. We're sharing Chem 101. Okay, you go with Professor Zilch, I'll stay here. Then you and I don't have to face each other every day in the dorm or the dining room or in Chem 101. It's no big punishment. We don't have a lot of the due process problems. And that would do two things. It would protect the roughly 40% of the women who they say don't report because they don't think it's a good idea. But then also this problem, which many people mention, of having to be associated with the guy. It's a large university. You go to your classes, I'll go to mine. You're in one dorm, I'm in another dorm. Big deal, restraining order. I won't go within 100 feet or 100 yards of you. If I see you in the dining room, I'll wait and come back later. No big problem, 40%. So there are solutions. I don't subscribe to the idea that colleges have to be completely out of this, but I don't think you can largely make, and particularly these smaller colleges, yeah, the idea that they can judge it, just like you can't say that every hospital in the United States can treat Ebola. That's crazy. This is just as crazy.
Even these interim measures, like stay-away orders, are subject to some due process limits, as the D.C. Court of Appeals made clear in Tyree versus Evans. And it's important to keep in mind when you endorse them that OCR is not just asking that these be applied to people who've experienced or claim to have experienced forcible rape. They're demanding it in essentially every harassment case, which means you could have somebody who accuses a professor based on their discussion of sexual issues in their class. And so this raises very serious potentially due process and free speech problems if you very broadly allow OCR to demand interim measures in every case.